Candidates, get ready for the passage. The appellant is aggrieved by the judgment dated 31st May 2022, passed by the High Court of Judicature at Allahabad, Lucknow bench upholding the order dated 9th December 2020, passed by the Central Administrative Tribunal Principal Bench that had turned down the challenge laid by him to an order dated 27th September 2019, passed by the Central Board of Direct Taxes, Department of Revenue, Ministry of Finance, Government of India, communicating the decision of the President of India to compulsorily retire him in exercise of powers conferred under Rule 56J of the Fundamental Rules. The present case has a checkered history with multiple rounds of litigations of the matter. We may briefly refer to some facts relevant for deciding the present appeal. The appellant was a permanent commissioned officer in the Indian Army inducted in the year 1980. Due to a physical disability suffered by him in the course of army operations, he was demobilized and released from service. In the year 1989, the appellant qualified the civil services examination. He was appointed as an officer and allocated to the 1990 batch in the Indian Revenue Service. Aggrieved by a separate memo dated 30th January 2018 issued by the respondents on the basis of the aforesaid inspection of his office conducted on 29th and 30th November 2017, calling for his explanation in respect of some orders passed by him in his judicial quasi judicial capacity as a commissioner of income tax exemption. The appellant had to file OA number 332 of 2018 that was decided by the tribunal in his favor wide judgment date to 28th May 2019. In its judgment, the tribunal relied on the order dated 15th May 2018 passed by the High Court in WP number 13390 of 2018, declaring that the inspection conducted by the department was under jurisdiction and there was no justification for withholding the vigilance clearance of the appellant on the basis of the said inspection, noting that the memo dated 30th January 2018 issued by the respondents calling for an explanation from the appellant was premised on the very same inspection conducted by the department. The tribunal reiterated the string of finding returned by it in favor of the appellant in its earlier common judgment dated 6th March 2019 and proceeded to quash the memo dated 30th January 2018 issued by the respondents. It was further held that the said order will adversely impact forwarding of the appellant as member IT80 terms of the recommendations made by the selection committee in its meeting held on 26th August 2018 in the teeth of the series of orders passed by the tribunal and the High Court in favor of the appellant. The respondents elected to withhold his vigilance clearance, thereby compelling the appellant to file contempt petitions against the concerned officers for non compliance of the orders passed. In the proceedings before the High Court, on the one hand, the respondents kept seeking adjournments on the ground that steps were being taken to forward the appellant's name of the ACC for being processed for his appointment as member IT80 till as late as on 31st May 2019, on which date they were granted one last opportunity for making compliance and At their request, the matter was adjourned to 9th July 2019, and on the other hand, the respondent slapped the appellant with a charge memorandum dated 17th June 2019 and suspended him on 1st July 2019, having regard to the fact that the respondents did not take the disciplinary proceedings initiated against the appellant to its legal conclusion and instead issued an order compulsorily retiring him. This court does not deem it expedient